you received a copy of the PSI, of course, right?
Yes, Your Honor, I do apologize. It said that we had
Okay.
mailed it.
No, it's fine. So in the matter of the people of the state of Michigan versus John Lewis Swiker, file number 23-21496FH, I have Matthew Murphy appearing on behalf of Mr. Swiker. We have had an opportunity now to review the pre-sentence report prepared by the District Court Probation Department. Mr. Swiker, are you satisfied that we read through that?
Yes, I am.
Are you satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yes, I am.
All right. Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not that I'm aware of, Your Honor, no.
All right, because this is a misdemeanor, there are no guidelines. So, Mr. Murphy, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Schweikert?
Yes, Your Honor. Mr. Schweikert had tried to get into sobriety court, and they actually reviewed him and said that he wasn't eligible because he did not have a severe alcohol disorder. As he indicated, it was 15 years ago when he quit drinking. He had a relapse because of a funeral, which is not a common thing. So I don't think he's the typical person that you would see because he's not having typical triggers. Obviously, he understands that when something happens, he can't turn back to substance abuse. But again, I don't think that it's something that occurs regularly. And I think moving forward, he realizes that he's not, this shouldn't occur. I would ask the court, again, considering that he is, it has been quite a while since he had the priors, his limited income and his age and the issues that he has, medical issues, I would ask the court to consider suspending the jail time. I don't think incarceration is necessary. I do believe that Mr. Schweikert will perform well on probation and that the court won't see him again in the courtroom.
Okay. Mr. Schweikert, is there anything you'd like to say on your own behalf?
No.
No. Okay. So, Mr. Schweikert, finding costs on a misdemeanor. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines that don't apply, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. So, Mr. Schweikert, your license is suspended, correct?
Correct.
Where did you get a car to drive?
I borrowed it.
Okay, all right. So it's a sentence of the court that you will be placed on probation for a period of 12 months. During that term of probation, you will not consume any alcohol or any controlled substances not prescribed to you. You are not to drive an automobile. Do you understand?
Yes.
You will attend a victim impact panel and complete required counseling. You shall attend 12-step meetings if the probation officer requires it. There will be regular and random testing for alcohol. There'll be search and seizure, which means they can come in your house, your car, and look for alcohol if they believe you have alcohol. Do you understand?
Yes.
They can also, they're going to have you sign all releases of information for counseling and so forth, so they can get that information. And there is not to be any alcohol in your home. Do you understand?
Yes.
There is a crime victim rights fee of $75, state costs in the amount of $50. Ms. Spade, is there a law enforcement fee on these? Yep.
$100.
Yep, $100 law enforcement fee. There is $30 a month supervision fee. And I'm gonna assess a $200 fine. And I am, because you're indigent, I'm not gonna assess court costs or attorney fees, so usually that would be a $750 court cost and $450 in attorney fees. But based on your income and your situation, you're not able to pay that. I get it. So I'm assessing what I have to assess. You understand? Okay,
Thank you, Your Honor.
so Mr. Murphy, I'm sorry, what?
I said, thank you, Your Honor.
Oh, you're welcome. You're just not getting paid, Mr. Murphy. So, Mr. Schweiker, you do have the right to appeal this sentence. And my bailiff's going to bring down to you 3 copies of your notice of right to appellate review. You're going to initial and date the top copy. Today is July 5 or January 5. And just to acknowledge you received the paperwork. If you wish to appeal your sentence, you would fill out the information on the forms that we gave you and mail it to the address listed on the form within 42 days. Okay? So why don't you go stop down at the probation department on the first floor right now? And I'm gonna have the paperwork sent down, okay? All right, thank you.
Thank you.
Thank you, Your Honor. Thank you, Mr. Schweikert. You have a good day.
And I suspended the 5 days jail, so there won't be a 5 days of jail. All right.
Thank you, Your Honor.
Got everything in there. No driving is on there? Yeah. There's some other boxes in there. Let me do this one. I just don't need to make one. Don't mind running it down. Correct. All right, Mr. Murphy, is anybody in here for Mr. Murphy? Okay. So Mr. Murphy is, I have 2 MDOC, but I believe those are Miss Underwood. I'll call the jail for Mr. Hyder, but in the interim, I will take Miss Borders, okay?
Yes, Your Honor. Thank you.
Good morning, Your Honor.
Hold on.
Mr. Hyder's.
Oh, is he here?
No, I
All right. All right.
don't know, Sherry or Keith.
Okay. We'll figure it out. Okay, this is in the matter of the state of Michigan versus Joseph James Green. Miss Borders, you and your client need to stand at the podium.
Oh,
Yeah. I'm sorry, we do a different, district court does one thing, we do another
I
thing,
understand.
you know. So, and this is file number 23-231484FY. I have Phoebe McClure appearing on behalf of the people and Angela Borders appearing on behalf of Mr. Green. This is the date and time set for sentencing in this matter. I did receive a sentencing memorandum from Miss Borders, and I have reviewed that. Ms. McClure, you received that as well?
Yes.
And it just reiterated the plea and the background on this case, so I appreciate that. Mr. Green, you are Joseph James Green, correct? And now, Mr. Green, you received a copy of the Michigan Department of Corrections pre-sentence investigation report.
Yes.
And you've had ample time to review that with your attorney?
Yes.
Are you satisfied with Ms. Borders as your attorney and the advice that she has given you?
Yes.
All right, and Ms. McClure, the people received a copy as well?
Yes, and Judge, I just want to make sure you get a copy of our sentence and answer to the sentence memo.
No.
Can I give that to you now then?
Is it, well, let me ask, I know Ms. Borders just basically was, I will take a copy of it,
Okay.
but,
I know Mr. Jones got it and reviewed it.
yeah,
May I approach?
of course. Okay, give me 2 seconds.
We do have an agreement on guidelines now though, but it does talk about guidelines.
It doesn't really, all right, so, Ms. Borders, do you, and I'm not talking about guidelines yet, do you wish to explain or challenge the accuracy or relevancy of any of the information in the pre-sentence report?
Do not.
Ms. McClure?
None, Your Honor.
All right. Do you, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? In
No,
this
Your Honor.
case, I show that he has 0 prior felonies, 0 prior misdemeanors, and a 0 juvenile record.
That is correct, Your
All
Honor.
right. Okay, the probation department computed in my PSI the sentencing guidelines to be, hold on, they changed my forms on me. So on computers use, well, let me go back one more, so counts. Okay, so on the count of capturing, distributing an image of an unclothed person, they calculated the PRVs to be 20, the OBs to be 0, and the guidelines to be 0 to 9.
We have made it, we have agreed to. Sorry, yes, that is it.
Okay, so that one's correct.
Well, actually, Your Honor, we've agreed to amend the totality of the scoring of the offense variables. Any in which allow for scoring of OB 10 to be scored at 10 points. Which does change the guidelines, and I believe Mr. Jones has made that.
0 to 11 on that section.
All right, so OB 10 will be scored at 0, so the OBs will now be 10, and it'll be 0 to 11 months.
OB 10 is scored at 10 with 10 points. Yep, that's 0 to 11.
All right, so I'm gonna wipe that out and just write in 0 to
Then I'll
11,
make the correction for you, Judge.
or I'm just gonna sign it.
Thanks.
All right. Okay, so then on the offense tampering with evidence, he has the PRVs at 20, but we're scoring OB 10 at 10 as well.
Yes, Your Honor.
So the OBs will now be 10. And Mr. Jones, what does that take the sentencing guideline range to?
It goes to 0 to 17.
And you agree with that, Ms. McClure and Ms. Borders?
Yes. Yes.
Okay. Moving on to the count surveilling an unclothed person. Mr. Jones had the PRVs at 20, the OBs at 0, but we are changing OB 10 to 10, which will make total OBs 10, correct, Ms. McClure? And the guidelines will be
0 to 17.
on computers using to commit a crime. The PRVs are 0, the OBs are 0. No, yes?
It would be 20 on PRV 7 and OB 10 would be 10.
So we're changing PRVs.
7 to 20.
So the total PRVs would be 20 and the OB 10 would be changed to 10.
Correct.
So OB's total would be 10
Correct.
and the guidelines would be now
0 to 9.
0 to 9. On the count computers using to commit a crime, maximum penalty 2 to 4 years. Any changes to the PRVs?
So PRV 7, I don't believe is reflected as 20 and OB 10 would be 10.
All right.
My understanding that they have a news report system, Your Honor, so I think that that's what happened there.
No problem. What are the total, what's the sentencing guideline range?
That would be 0 to 9, Judge.
And I believe that concludes all counts that he pled to.
I
Okay.
think so.
You agree with all of that, Ms. McClure?
Yes,
All right. Before the court passes sentence, do you, Ms. McClure, do we have anybody that wishes to speak today?
no, Judge.
All right. Is there anything you'd like to say on behalf of the people?
Just that the only thing the sentencing memo indicates on behalf of the people is that we do agree with the recommendation and the agreement in this case to 9 months in Lenawee County Jail, and we would ask that you follow. Or I'm sorry, 90 days. I apologize.
Okay.
And we would ask that you follow that.
Okay. So, Ms. Borders, is there anything you'd like to say on behalf of your client?
But first, I would like to let you know that the court, or my client wishes to speak, and I don't know if the court would like him to make a statement before me or.
Nope, you first.
Okay, Your Honor, thank you. I apologize for taking the court's time to articulate this, but I do feel that it's important, and I, more than many, understand the effects of this type of a crime on a victim. So it's a very delicate argument that I have to make, understanding that she will likely carry the effects of this crime with her for the rest of her life. But we've all been in this courthouse a long time, and we've seen a lot of people come through this court with much more serious offenses and have been convicted of much less of crime. And the reason that I state that in this particular case, Your Honor, is because my client, the reason, and the prosecutor, and not this prosecutor, but the prosecutor that handled this case told me as much, is that my client immediately confessed to everything that he did in this case. He furthermore consented to to turning over every single electronic device or storage device of any stored electronic data over to law enforcement so they could examine it. And in the process of that, they found 2 images. One was an image of the victim unclothed from the waist up, and the other was a video of her from the waist up. And that is 15 years worth of hard data. And my client has committed no crimes. Since this, my client, one of the particular facts that the prosecutor liked to point out in this particular case was that my client tampered with evidence, which was the device that this information was discovered upon. And my client was discovered, this device was discovered and turned over to his wife, who was rightfully extremely upset. And there was a confrontation. And my client had no intention of tampering with evidence in the sense that it is a crime and that it would be used against him. He was trying to satisfy his wife in a moment of desperation to try to make her happy. Okay, it's gone, I broke it, it's over. And then afterwards, he not only took that device to the Adrian Police Department thinking he could turn that device over to them, he was told by the Adrian Police Department that they couldn't take it because that was not their jurisdiction, and he sent it over to the Sheriff's Department. And he went there and tried to turn the device over to them as well, and they did not accept it. He then went to work and disposed of the device. We pled to it because he admitted to doing that, and you can't really get around it. However, Mr. Green has since lost his job because of this crime. He has pled to 5 felonies because of this crime. Having no criminal history, he is no longer freely able to travel throughout the world in his retirement. He cannot possess or own a gun for a long period of time. He has lost his family, which is what he regrets the most. And he did accept full responsibility for this and is extremely remorseful for that. And I don't think the one thing that he can get over, despite the consequences that he is going to be getting as a result of pleading guilty to these 5 felonies, is that he cannot repair the damage that he has caused to his family. He did, though, immediately within the week of the discovery of this crime, enroll in counseling, and has been continuously going to counseling to address whatever it was that caused him to commit this crime in the first place. I asked the court that we did not agree to a 90-day sentence. We agreed to cap the jail at 90 days, no more than 90 days. And I'm asking that the court either suspend that sentence or sentence him to a lesser amount of jail to consider the factors that this court has to, for the purpose of a sentence, my client is definitely served a sentence of many other things besides jail that have definitely punished him for what he did. Anyone that loses their entire career and has to suffer the consequences of what pleading to 5 felonies means is certainly a deterrence against committing this type of crime for others. And I am simply asking the court allow him to continue in his progress that he's been making in counseling and be able to go forward with his life and try to repair the damage that he has caused as a result of committing this crime. And again, I do not want anything that I say this today is not intended to minimize the effect that my client's crime was or had on the victim. Thank you.
Thank you. Sir, do you have anything you'd like to say on your own behalf?
Well, I wrote a thing that I wanted to say, and it starts out with Brian, that's who the victim was. She's not here, but I'll say it. I first want to express my deepest apology to you. What I did was wrong, and you and your family, and no one else, deserved that, or especially deserved that because of me. I also want to know that nothing that I want you to, I'm sorry, I want you to know you did nothing wrong. I take full responsibility for my actions. You are a good person. Knowing my actions had affected your trust, I wish I could have taken it all back. The emotional void that this has put in you, and I am sorry for that. Knowing this will stay with you for the rest of your life really hurts. And I'm very sorry for that. But getting caught has helped me. I started counseling. I found my way back into the church, and I'm working on being a better person. Grant, I'm very sorry for what my actions were, and I hope someday you can forgive me.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. I have in my notes from probably a Cobb's conference or a meeting with the attorneys that the Cobb's agreement would be that you would be sentenced to 90 days or less and the offenses would not stack, which means that today you could have been facing multiple prison terms that stacked.
Right.
So your attorney did an excellent job and you should be very grateful to her that you're not going to prison on multiple sentences. Do you understand?
Yes.
It's a sentence of the court that you would be placed on probation for a period of 3 years. During that term of probation, you are to pay $130 crime victim rights fee, $340 in state costs, and that's let's see, that would be $68 on each count pled to, $60 DNA fee. There's a $30 per month supervision fee and $60 if you're required to wear a tether. There's also $750 in court costs, and I will assess a $500 fine on each count that you pled to. It allows me to assess up to $5,000, but I'm only doing a $500 fine on each count pled to. You will serve 90 days in the Lenawee County Jail. You have 0 credit. You are to have no contact with the victim, Breonna Tanner, directly or indirectly. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the probation department or this court. You are to make a truthful report to the probation officer monthly or as often as they may require, either in person or in writing as required. You must submit to search and seizure of your person and property, including but not limited to your vehicle, residence, computer without need of warrant if the field agent has reasonable cause to believe you have items which violate the conditions of your probation. You are not to have unsupervised contact with any minor children and any relatives that are minor children. You cannot be in their presence without adult supervision. Yeah, I think that covers everything. So
I don't wish to challenge the court sentence, but I just, it's outside the recommendation. Of course, the judge has the complete decision-making power in this, but
fines are discretionary on my part.
as far as the no contact with minor children, this person was an adult. The victim in this matter was an adult, and I just wanted to see if that's something that we could all address.
Mr. Jones, what would your position be on that due to the nature of the offense?
I have a position, to be honest with you, Judge. I think that would be the court's discretion. Ms. Borders is correct. The victim was mid-30s.
Okay, all right, I'll remove that term then. All right, now you do those two terms. So you do have the right to appeal this sentence. So my bailiff's going to hand down to you your notice of right to appellate review. You're going to initial and date one copy. Just acknowledge you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail them to the address listed on the form within 42 days.
Yes.
Or in the custody of the sheriff's department. If Ms. Borders, and if you wanted to fill it out now, you can take a moment to do it,
Okay, thank you.
or you can meet with them. All right. Let's see. All right, I have a gentleman from MDOC. Are you Mr. Jackson?
Yes, I am.
Mr. Jackson, let me get your file. And I believe Mr. Hyder, we're ready for him. Okay, that's all right. The court record will reflect and receive back the acknowledgement of appellate rights. Okay, so Mr. Jackson, I have your file. And we have your TCN done. So that's good. So Mr. Jackson, Miss Underwood is your attorney, or no, Mr. Glazier is your attorney. And he's probably next door in front of the judge next door, okay? Because we have two judges next to each other and they go back and forth. So what I'm gonna do is rename your Zoom and I'm going to put you in the waiting room because I don't have anything going on anyway to watch. And when Mr. Glazier gets here, I will bring you back in, okay?
Yes, ma'am.
All right, thank you.
Yep.
Mr. Murphy, Mr. Murphy, are you ready for Mr. Hyder?
Yes, Your Honor.
He's in person as well, and I can't let him Zoom with you. You know that, right?
Yes, Your Honor. I guess we would address on the record how he wanted to proceed with it and go from there.
Okay, have you met with him?
I have not been able to meet with him, Your Honor, and I don't believe that Mr. Malaro was able to before either.
Of course not. Okay, so we can adjourn it. That's fine. If you want.
Okay, I figured if he wanted to, I didn't know if he wanted to proceed. I wasn't sure.
You know, Rhonda's around. I'm running around because she's got court in 50 million places, so she could review it with them if she has time. So I could do that for you. Then you would owe Miss Underwood.
I was gonna say, I have no objection to adjourning it, Judge. The only thing I would ask for if the court does adjourn it is to remand him into custody to begin his sentence.
He's in jail.
Oh, I thought he was here.
No.
Yeah, in lockup.
Oh, I'm sorry. Okay. All right. I'm sorry. I thought you meant he was like out here.
No, no. Miss Underwood. Because you are so amazing, would you be willing to review a PSI with someone in lockup? The reason I ask is it is a Mr. Malaro file.
Is this Mr. Hyder?
Yes,
I already did.
because you are a rock star. Okay, never mind.
Your Honor, I just have one question, and I'm hoping, because I obviously don't know, I didn't take the plea. Mr. Hyder says there's a discrepancy in that he pled to aggravated domestic violence, a 1-year misdemeanor.
Yeah, I was gonna point that out. He pled to a 1-year DV second, and what's in the PSI is a felony charge.
So that's fine, and we'll fix that when we get him here, but we're gonna have him brought down.
And Your Honor, I would like,
And I gotta call the case. so
Okay.
Let me do that. So he did plead to a 1-year misdemeanor domestic violence second offense, I think, on file number 23-21511, right?
Yeah, I believe so, yeah.
Oh, nope, you gotta stand at the podium. All right, okay, so we will, all right, so you gonna represent Mr. Hyder today? All right, so Mr. Murphy, did you have anything else with me?
No, Your Honor, I'm just gonna stay and observe, just in case I had anything to chime in on, so.
Observe the master in my courtroom, Miss Underwood. All right, so this is in the matter of the people of the state of Michigan versus James Allen Hyder. We have two files, 23-21512 FH and 23-21511 FH. I have Ron Underwood appearing today on behalf of Mr. Hyder. I have Phoebe McClure appearing on behalf of the people. And Mr. Hyder, I know that your attorney was Mr. Malaro, and are you satisfied having Miss Underwood represent you today?
Yes, Your Honor.
Okay, so Mr. Hyder, your attorney has already addressed with the court that there's some discrepancies. But first, I want to ask you, have you had an opportunity to read and review the pre-sentence report?
Yes, ma'am.
Have you had an opportunity to discuss that pre-sentence report with Miss Underwood?
Yes, ma'am.
All right, and this was prepared by Sarah Teskey. All right, so Miss Underwood, first let's address on the current conviction page, final charges on file number 23-21511, which is page 1. It says domestic violence aggravated second offense, but as you correctly stated in the file, that is actually a 1-year misdemeanor, correct?
That's correct, Your Honor.
Okay, and Miss McClure, you've had an opportunity to review that?
Yes,
And would you agree that's a 1-year misdemeanor?
it is, Your Honor.
All right, Ms. Teskey, can you make that change? Sarah Teskey, are you with us?
I'm with you, Judge.
Okay, so can you make that change in the pre-sentence report?
To make it a 1-year misdemeanor?
He pled to domestic violence second offense, which was a 1-year misdemeanor, not aggravated second. Is that correct, Ms. McClure?
That is correct.
For some reason, on the page 1 under current convictions, the number got entered and it pulled up the 5-year felony, domestic violence aggravated. It says 5-year felony. But under plea agreement, it says he pled guilty to count 1 domestic violence second offense, and that's a misdemeanor.
Okay, shoot. Yeah, we'll have to get that changed.
Okay,
So
so
we'll
that's a
Are
1-year.
you sentencing him today, Your Honor?
Yeah, we're doing it right now.
Okay, all right. I thought this was gonna be adjourned.
Nope, Miss Underwood swooped in and took care of everything. All right, and then Miss Underwood, the other charge on 23-21512 FH is listed as a 20-year felony, and that's correct.
That's correct.
Yes, okay. So the guidelines for the domestic violence will be struck, so we won't have those. Do you, Ms. Underwood, other than that, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
I don't believe Mr. Hyder does, Your Honor.
Okay, and the Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, it does not, Your
All
Honor.
right, on file number 23-21512FH, the probation department has calculated the minimum sentencing guidelines to be 0 to 17 months. Do you agree with that computation of guidelines?
We would agree with that.
All right. And you agree with them as well?
Yes.
Okay, I always forget to ask them. Sorry. So, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Hyder?
Just that it's my understanding, Your Honor, that Mr. Hyder has been accepted into the drug court program. And he looks forward to that. Your Honor, Mr. Hyder has used his time in jail very wisely. He's completed anger management, sanitation and hygiene, a student guide to drug and alcohol abuse, careers without college, safe lifting practice and manual material handling, food service worker, annual food service training, forklift material handling.
Wait, is
forklift
that
safety.
since he's been in jail for 142 days?
Yep. And
Okay.
adult and child CPR, Your Honor.
All
So
right.
I can't remember
I
the
don't think
last
I've ever.
person who I've seen in jail who've used their time that way.
No, I've
And
never
it's
had a
pretty
defendant do
impressive
that.
to me.
Okay.
Your Honor, I understand the recommendation is for a year jail. I hope with the drug court recommendation that jail would be suspended to allow him to begin his participation in drug court as soon as possible, Your Honor. I'm not sure rehabilitation at this point would be warranted since he has been in jail for a long time. But I think Mr. Hyder is a prime candidate to be out, to be getting employment and to be participating in drug court. And we would ask for that today.
All right, Ms. Teskey, because he's been accepted to drug court, the recommendation is 1 year in jail. Will that change at all with acceptance to the drug court for like a rehab facility or suspending the balance?
Your Honor, my intention was to send him to residential treatment. So,
All right, thank you. Mr. Hyder, anything you want to say on your own behalf?
Besides being trustee, I went to every class that I've been able to, the engagement group and AA. I went for the past 5 months. I went up every week and I'm straight to start drug court as soon as possible. Get a real job, so being trustee.
All right, very good. Ms. McClure, anything on behalf of the people?
Just that, given that there is that change in the PSI, obviously the recommendation on the domestic violence would change. I would ask the court to follow the 1 year recommendation and allow Mr. Hyder to do drug court following that sentence. I don't think probation on the domestic violence offense is appropriate, given that he was on probation at the time of the offense and he has repeated assaultive convictions over and over. I understand he has obviously a substance abuse issue, but he needs to also work on his assaultive behavior and maybe some anger management. So I would just ask that the 1 year be adopted as to that sentence and then the rest of the recommendation be adopted as to the possession of methamphetamine.
Thank you. In determining the appropriate sentence in this case, the court has considered the seriousness of the offenses, your history, the principle proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to their commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law and the protection of society. It's the sentence of the court that on file number 23-21511FH, you will, I have to reduce that probation term to 2 years because I can't do 3 years on a misdemeanor. You'll be placed on probation for a period of 2 years. You will serve 1 year in the Lenawee County Jail on this file, but you may be released to an inpatient treatment program. At that program, they'll offer services like domestic violence counseling, mental health counseling, whatever it might be. On During that term of probation, you will obey and comply with all the articles of probation, including admission into drug court. Understand, if you leave inpatient treatment, that's a violation of probation. Do you understand?
Yes.
Okay. And on that file, you will pay. Let me get there. Find my little misdemeanor thing. Get there. On a domestic violence. Now it's impaired. Oh, here we go. There is a $100 fine, $50 in state costs, $75 crime victim rights fee. And as I said, credit, I think I said it, credit for 142 days already served. On file number 23-21512FH, sentence of the court will be placed on probation for a period of 3 years. You will receive credit for 142 days jail you've already served. During the term of probation, you will obey and comply with all the articles of your probation, not to have alcohol in your home, you're not to have any drugs in your home, you're not to be around people that have drugs. Do you understand? We can search your house, we can search your car, we can search your phone if we believe that you are using. Do you understand that? Drug court is a pretty intense program. During phase 1, which lasts for quite a few months, your job is not the most important thing, your family is not the most important thing. The most important thing in your world will be getting sober and staying sober. And then it gets easier. But drug court is first. Do you understand? Okay. You're not, let's see. You will pay a crime victim rights assessment fee in the amount of $130 per month supervision fee, $60 if you have to wear a tether, court costs in the amount of $750. $450 in attorney fees, $68 in state costs. You are ordered into the Lenawee County Recovery Court. You must follow all rules and recommendations. I don't see any restitution in anywhere, so no, I don't see any. So, Mr. Hyder, these different courts we have mental health court, we have veterans court, we have sobriety court, and we have this adult recovery program for people with addiction issues. So it's a different world. If you are honest, if you make a mistake, we give you services. If you lie about it, you go to jail. So you don't automatically go to jail. Like if you have a slip up or you need help, you come, we give you help. As long as you're honest and forthcoming. So it's different mindset than normal probation. Do you understand? Okay. So you had his paperwork. Yes. So Ms. Teskey will be working on finding a bed for you. And it usually takes less than 2 weeks. And once she'll be over to see you. And once she does that, she'll work on the transfer for that. Do you understand? Okay. Now, my bailiff's going to hand down to you your notice of right to appellate review on each of your files. Okay. You're going to initial and date 1 copy for each file. That's going to come back to me just to acknowledge you received the paperwork. The other copies are for you, and if you wish to appeal your sentence, you would fill out the information on the form, mail it to the address listed on the form within 42 days. Ms. Teskey, anything I'm missing?
No, Your Honor.
Thank you.
I have Casey McKenzie with you as well, right?
Yes. Yes. Miss Adams, I'm going to call over to get, he's in jail, right?
He is.
Who is my pickup yesterday? I felt probably shouldn't have proceeded. Yesterday. Hi, this is Judge Anslone. I wondered if I could get Casey McKenzie.
Sure thing, I'll let booking.
All right, awesome. Thank you. Bye-bye. All right. Hold on. Yeah, hold on. So, Mr. Hyder, I wish you the best of luck. I look forward to seeing you in the drug court. It's an amazing program. All right.
Thank you.
Thank you. Are you ready for Mr. Pagan?
I'm ready for Mr. Pagan.
Did you already talk to him?
Yeah.
Remember, it's Pagan.
Is it Pagan?
Pagan. so, all right, we'll take Mr. Pagan. I also have Derek Jackson and Frederick Wilson.
Hmm?
I have Derek Jackson and Frederick Wilson.
I have Frederick Wilson. Is he on the Zoom?
Yeah,
Okay.
let me bring him in. Mr. Wilson,
I'm gonna have to talk to him.
okay,
Yeah.
so, all right, so Mr. Wilson, I have Miss Underwood here. Miss Underwood expressed that she was not able to meet with you. So she would like to talk to you for a few minutes before we proceed today, all right?
All right.
And then, is this the one? There's one.
Judge, he's making an arraignment, right?
It's a bopper.
Okay, I thought so.
All right, so, are they bringing Pagan down right now? So, Mr. Wilson, we're gonna do one sentencing before you, and then when I'm done with that one, we will, Miss Underwood will go back and go in a breakout room with you, okay?
Yeah.
Okay, so you just hang tight for a moment.
Thank you.
Thank you. Have a good weekend this weekend.
Yeah, no, I don't have, yeah, I don't have that.
Are you taking Derek Jackson today as well?
I don't think I can take Derek Jackson.
It's Mr. Glazier, is he here?
Yeah. He's not here. I can't take Jackson.
I know,
You remember
I know.
my history with Mr.
Miss
Jackson.
McGrain, was Mr. Glazier down the hall?
Judge, I've been downstairs. I don't know.
Miss Adams, could you perhaps call the PD's office and?
Sure can.
Thank you, Your Honor.
We're at the jail. Hi, jail. How are you? All
Doing all right here, trying to get this set up.
right, thank you. I never see a face, I just see a torso. Okay, so let me text her and let her know. And then,
And I have her instructions, so she can just message me if she wants to.
all right, send her a message. Pagan.
Oh,
How do you pronounce your last name? We've been fighting about it.
Oh, pagan's like pagan.
Yeah?
Yeah.
So for once I was right, Miss Underwood, it's Pagan. All right.
the court is always right.
Yeah, that's what they say. All right, so this is in the matter of the people of the state of Michigan versus Ricky Lee Pagan, file number 22-21142FH. So, Mr. Pagan, we are here today for sentencing. Did you have a chance to talk to Miss Underwood?
Yes, ma'am.
All right, and did you have a chance to review the pre-sentence report with
Yes,
her?
ma'am.
All right, are you satisfied with Miss Underwood and the advice that she's given you?
Yes.
Okay. Miss Underwood, do you wish to explain or challenge the accuracy or relevancy of any of the information in the pre-sentence report?
We do not, Your Honor.
All right. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not, Your Honor.
All right. On this attempted count, the probation department has calculated the minimum sentencing guidelines to be 5 to 17 months. Do you agree with that calculation of guidelines?
We would agree with that, Your Honor.
All right. All right, and before the court passes sentence, all right, I'm getting some background noise, so I'm gonna put the jail in the waiting room as well as Mr. Wilson real quick. All right, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Pagan?
Your Honor, Mr. Pagan understands that what he did was unacceptable. I think Mr. Pagan has certain mental issues that he struggles with, Your Honor. The court in this case gave Mr. Pagan a cobs to the low end of the guidelines, Your Honor. And I would hope the court will follow through with that today. And Mr. Pagan very much appreciates the court's attention and time to this matter.
So what sentence are you asking the court to give him?
The 5 months, Your Honor.
All right, Mr. Pagan, is there anything you'd like to say on your own behalf?
Oh, man.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle, proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for law, and the protection of society. So, Mr. Pagan, this is like your 4th offense doing this, right?
Yes.
Okay. And when is and you're still serving on your armed robbery, right?
No, I done did all the rest of the time that was given to me already. I'm right. I had did the time that was given to me already for the case I had called. I already did that, but I'm just doing flop time right now.
Okay. And then every time you get an assault of a prison employee, you do more time. You understand that?
Yeah.
So, there's either, are you getting proper treatment in the prison? Like in terms of medication and assistance?
Sometimes I am, sometimes not.
So, Mr. Pagan, if you ever want to get out and you want to go home, you have to control your behavior. Okay? It's a sentence of the court that you will serve. So, Mr. Moore, to do the 5 months, with your recommendation, it wouldn't be 5 months with the Michigan Department of Corrections. I would just give him 5 months credit for time served, or what?
Well, we cannot give them credit for time served. If you want to give them the low end and give them 5 month prison term, you can. It's got to
Would
be
I do
consecutive.
just the 5 months to 2 years, 6 months?
Correct.
Okay, I just wanted to make sure I said it right.
Yes.
Okay, so it's a sentence of the court that you will serve a period of 5 months to 2 years and 6 months with the Michigan Department of Corrections. I can't give you any credit. You understand? Because you're already in prison. We talked about that before, remember?
Yeah.
There's $130 crime victim rights fee and $68 in state costs. I'm assuming there's no DNA fee, Mr. Moore, because he's in prison.
Correct.
All right, so there's no DNA fee. Now, Mr. Pagan, you do have the right to appeal this sentence, and my bailiff's going to hand down to you your notice of right to appellate review.
Your Honor, can we address the concurrent or consecutive?
Oh, and it is, sir, you understand it is consecutive to the sentence you're serving now, right?
What do you mean?
So when you're an MDOC
Yeah.
and you commit an offense, you can't get credit for time served.
Right.
So when you finish serving whatever sentence you're serving now, then you got to do 5 months on this.
Oh, okay.
But that means you have to not get in trouble.
Right.
Stay out of trouble.
Yeah.
Okay.
So you're talking about you're talking about when I get a parole and I'm about to go home, this client right here is gonna come pick me up and I have to do the time then?
You're gonna stay wherever you are and just do your extra 5 months.
I don't understand because every case, hold on, listen. Every case I've been caught, they had made me do 5 or 2 or 3 years in the gate, and then I just went on and did my bit. So I don't understand when it says consecutive.
So when you're an inmate and you commit offense, you have to serve it like after you finish your current sentence. So say you.
Oh, yeah, okay.
Yeah, okay. Now, Mr. Pagan, you're initially dating one copy for me, just to acknowledge you received the paperwork. And the other copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form, and mail it to the address listed on the form within 42 days. Do you understand that? Okay. Where are you currently at, Mr. Pagan?
I'm at WCC Woodland Facility.
Okay. I wish you the best of luck.
Thank you.
Stay out of trouble. All right, so let's bring, let's see. Oh, I got Mr. Glazier at the jail.
Go back and talk to Mr. Wilson.
Are you gonna do Casey McKenzie, aren't you? So let me bring him first. Because you can talk to both of them when you go back. Actually, you can go, are you going to my back room to log in?
Yeah.
All right, we can let her,
Yeah.
I'm back in Judge Olsabers.
okay.
Yeah.
Do you want the bailiff to let you back hallway?
Yeah.
Okay. Go that way. He's gonna let you run down the back hallway. All right, so Mr. McKenzie, can you hear me?
Yes, ma'am.
All right, Mr. in the matter of the people of the state of Michigan versus Casey Michael McKenzie, file number 23-21324FH. Mr. McKenzie, how you feeling today?
A lot better than I did a couple days ago, I know that.
Okay, good. All right, so Mr. McKenzie, we are here on two things. One is a show cause for violation of probation, which alleges that when you were released from jail, you were supposed to go to Hope House Residential Treatment Program. And then upon your discharge, report to probation. You were released from jail on October 27 of 23 in order to go to Hope House, and you failed to go to Hope House or report to probation. So do you understand that's one allegation against you today?
Yes, ma'am.
And then, sir, you're on probation for carrying a concealed weapon, which is not a 5-year. I'm looking, I don't have it. Hold on, we're gonna look that up. Okay. Must have had, examination waiver. Hold on, let me get back there. It's kind of a messy file. So carrying concealed carries a maximum penalty of up to 5 years in prison if you plead guilty or are found guilty of this violation. Do you understand that?
Yes.
Okay, now we're also here. Oh, I'm sorry, go ahead, sir.
Is that a new case or something?
No, it's your old case that you were supposed to be on probation for, but kind of dipped out on me. So you already pled to that case and you're on probation for it.
Okay, I understand now.
Okay, and then when they mailed you that show cause at the address we had for you to appear for that probation violation hearing, you didn't show up for that hearing, so we also have a bench warrant for failure to appear at that hearing. Do you understand that?
Yeah, I do now. I do now.
Okay,
Yes.
and the maximum penalty for that contempt of court could be up to 93 days in jail. Do you understand that?
Yes, ma'am.
All right, so Mr. McKenzie, you do have a right to have an attorney represent you on this violation of probation and contempt of court. Would you like an attorney appointed to represent you?
Yes, ma'am.
Okay, so I'm gonna put you in a waiting room, and Miss Underwood has a client she has to speak to. And when she's done with that client, I'm gonna bring you back in, okay?
Yes, ma'am.
All right, so just hang tight. All right, so Mr. Wilson is represented by you. All right, so in the matter of the people of the state of Michigan versus, let me get this file, Frederick Dwayne Wilson, file number 23-21557FH. I have Brenda Underwood appearing on behalf of Mr. Wilson, and I have, okay, so here's, so I struggle to understand, Miss Underwood, how Mr. Wilson is an inmate of the Michigan Department of Corrections, yeah, I cannot get fingerprints on him. Like,
You don't have fingerprints, Your Honor?
no. And there has to be fingerprints on him because he's in prison. So, and this is an MBOC offense. So, Mr. Wilson, by any chance, after you were arraigned on this charge, did anybody there, like a state trooper, come and fingerprint you?
No.
So one of two things are gonna happen. I'm gonna show cause the warden and the Michigan State Trooper who investigated this offense. Let me call my chief prosecutor and see if perhaps our chief prosecutor can help me. I mean, he's a captive audience. He's not gonna go anywhere. Wouldn't be hard to fingerprint him. We'll try different chief prosecutor. Well, I'm not getting an answer. So the problem with this, Mr. Wilson, is by law, I can't sentence you without your fingerprints done, okay? So what I'm probably gonna do is send a very official looking letter to your warden as well as the chief of the Michigan State Police Post that's supposed to do this. And I am really sorry that this hasn't happened. And I'm only gonna move your sentencing. Ms. Adams, would a week be too soon to get a writ done?
I guess that just depends on how long that takes them to process all that.
The writs, you mean?
The writs and the fingerprints, yeah.
So I'm gonna move this out 2 weeks. And then I'm gonna make a lot of noise, Mr. Wilson, and be difficult so that people will accomplish this. So Ms. Adams, do I have a date out about 2 weeks from now?
January 19th, 8:15.
And Mr. Wilson, what facility are you at?
Mr. Wilson, you're still at Gus, aren't you?
Yeah.
Oh, that's much better. Why don't I just have them come in person and they can take them to the sheriff's department and fingerprint them?
Exactly, Your Honor.
Mr. Wilson, you want to take a road trip and come see me in person for sentencing?
Yes.
Okay, so I'm gonna schedule that sentencing in person at 8:15. And Mr.
Just
Wilson,
have the
I
prosecutor
apologize.
do a in-person writ, Your Honor.
Yep. So I'm making notes on that. So Mr. Wilson, we will be bringing you in person on January 19th at 8:15 in the morning. Can you get that person behind you in? Hi. So I'm Judge Angelone, and Mr. Wilson has not been fingerprinted, which is kind of unusual because he's kind of a captive audience. But whoever the trooper on this file was never fingerprinted him, so I can't sentence him unless he's been fingerprinted. So I'm going to adjourn his sentencing today to January 19th at 8:15 and require him to come in person so that I can see if I can get someone to fingerprint him. Okay?
Okay.
All right,
sounds
thank
good.
you.
Yep.
All right. Thank you, Mr. Wilson.
All right. Thank you.
Thank you. Okay, so Mr. Glazier, hold on, Ms. Underwood. Hold on. All right, Mr. McKenzie, I am going to put you in a breakout room with Miss Underwood. And let me see if you go automatically or you are going to have to join. Oh, he went automatically. Okay. All right, so Mr. Glazier, I have Derek Jackson. All right, Mr. Jackson, good morning and thank you for your patience. This is in the matter of the people of the state of Michigan versus Derek Anthony Jackson, file number 21-20643. FH. I have John Glazier appearing on behalf of Mr. Jackson. this is the date and time set for sentencing in this matter. Mr. Glazier, do you need a moment to speak with Mr. Jackson?
I don't know if he wants to. I think the recommendation, or might even been a Killebrew, was for 1 year in jail, and he has over 1,000 days credit.
Right.
So,
Mr. Jackson, did you receive a copy of the pre-sentence report?
No, I didn't.
Okay, so Mr. Glazier, why don't?
let me talk to him a second, Your Honor.
Yep. So Mr. Jackson, I'm gonna put you in a breakout room with Mr. Glazier. And he is going to go through it with you, okay?
Yes, ma'am.
All right, there you go. He's gone. So, Miss Adams, you in your office?
Yes, I am.
All right, so Muck versus Gilbert is at 1:30 today. So I moved that maybe after you left.
Oh, okay.
No, yeah, because that was the case from yesterday.
No, that was Schisler.
It was what?
Schlischler?
No, who were the attorneys? Wasn't it Turk and Smith that I was talking to at the bench conference yesterday? No? Okay. So, all right, in the matter of Casey Muck versus Mercedes Gilbert, file number 20-206482NI, no one's shown up. They requested the adjournment. They haven't showed up. Maybe they settled. I don't have a trial date, do I? No, so. In the matter of Karen Thornton versus Michael Thornton, file number 23-237131NZ, no one showed up. And, okay, so I have Miss Underwood and I have Mr. Glazier. So, Miss Underwood, you have another court to go to?
I have Judge Olsaber to go to, Your Honor.
All right, so I'm gonna bring your client back first, and then I'll bring Mr. Jackson back.
Did you say something about Bornson?
No.
Oh, I thought you said Bornson right before you.
All right. So, Mr. McKenzie, have you had a chance to speak with your attorney now?
Yes, ma'am.
And Mr. McKenzie, you hear and understand everything we're saying?
Yes.
Okay. And are you satisfied with Miss Underwood as your attorney and the advice that she's given you?
Somewhat, yeah.
Okay. You may not like her advice or what she said is going to happen, but do you feel that you've had ample time to ask her questions?
Yeah, yeah.
Okay, okay. Miss Underwood, how do you wish to proceed with Mr. McKenzie today?
I believe Mr. McKenzie wishes to accept responsibility and plead guilty to the violation.
Okay, all right. Mr. McKenzie, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, so Mr. McKenzie, we were here yesterday and I felt that we shouldn't proceed with your arraignment. So I scheduled it for today and brought you back today. So do you feel that you are in a position to proceed today?
Oh, yeah, yes.
Okay, all right, good. Now, you would ask for court-appointed counsel. We appointed Miss Underwood. You've had an opportunity to speak with her. And it's my understanding you're going to be pleading guilty to the violation of probation as well as the contempt of court for failure to appear. Is that correct?
Yes.
All right. Do you understand that you have a right to contest this violation of probation charge and to have a trial on it?
Yes.
Do you understand that throughout this trial, you will be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all of that?
Yes, ma'am.
You do not have to, I'm sorry, you do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand that?
Yes, ma'am.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes.
How do you plead to the charge that you violated the terms of your probation by failing to report to the Hope House Residential Treatment Program on your release from jail on, let's see, it looks like you were ordered to report on October 24 of 2020, or October 27 of 23, and that you failed to go to the Hope House or contact your probation officer when you're released from jail. Guilty or not guilty?
So we want to go. Yeah, I plead guilty on that.
Okay.
I was supposed to, I asked the court to take me there, and they said, and then they came over, they said, no problem, that Hope House would come get you, because I said I didn't want to leave. And then a week before I was getting out on the 7th or the 6th, they come over, do you want to get out a week early? I'm like, why? Get your own ride, we'll let you out in 2 days. So I get out and then don't go. I wish they would have came and got me like I asked that court, but yeah, I didn't follow through with that.
Okay. And then Mr. McKenzie, we mailed out a notice to appear for a probation violation hearing for you to appear on November 15th of 23 on that violation. And did you fail to appear that day?
Yeah.
So are you pleading guilty to failure to appear for the probation violation?
Yeah, I never had no indication there was, but clearly sometime there should have been one put out, so not sure of the date, but yeah.
All right, do you understand by pleading guilty, you'll be giving up the right to a trial, as I've already explained to you?
Yeah.
Has anything been promised to you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, ma'am.
And is it your own choice to plead guilty on both of these files?
Yes.
All right, so Mr. McKenzie, you stated that originally you had asked for someone to give you a ride to Hope House so that you got there, but they had a bed open up early so they could let you go a little bit early if you could get your own ride. Is that correct?
Yes.
Okay, and when you got out, instead of arranging for a ride, you just absconded from probation. Is that correct?
Yeah, my ride said they'd take me, and I got out, and the girl that had no intention of taking me. So.
Okay, and you never came back to Ms. Teskey and said, hey, I don't have a ride?
No, I freaked out and didn't know what to do.
Okay. And then we sent out a notice for you to appear for a probation violation on November 15th. Did you appear on November 15th of 2023?
I didn't, nor appear or know that I was supposed to appear. So no, I did not.
Okay. All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. He has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a probation violation report. Ms. Adams, what date would you like me to use for sentencing?
January 12th at 8:15.
So I'm going to set this over to January 12th at 8:15 in the morning. Mr. McKenzie, you have a right to be present in person, or you can appear via Zoom. How would you like to appear for sentencing?
In person.
Okay, so I'll mark down that you will appear in person, and Ms. Teskey will probably meet with you and do an updated report, and then we'll see you back here on January 12th at 8:15 in person, okay?
All right, thank you.
All right, thank you, Mr. McKenzie. Thank you, Ms. Underwood, for all your extra help today.
I think that's my docket with you.
You're good, thank you.
And nothing like someone making you look good in front of your boss. You gotta love that.
Gotta love it. All right, Mr. Glazier, I'm gonna bring Mr. Jackson back in.
Oh, another one of my fans. Goodbye.
All right, let me get on let me see, he's coming back. There we are. All right, Mr. Jackson, have you now had a chance to read and review the pre-sentence report?
Yes, I have.
Have you had an opportunity to discuss that with Mr. Glazier, who is your attorney?
Yes, I have.
Are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
Yes, I am.
All right, Mr. Glazier, do you wish to explain or challenge the accuracy or relevancy of any of the information in the pre-sentence report?
No, Your Honor.
All right. Probation department in this case has calculated, back there, the minimum sentencing guidelines to be 12 to 24 months. Do you agree with that computation of guidelines?
Yes, I do, Your Honor.
All right. Before the court passes sentence, the pre-sentence report didn't disclose any prior convictions in which there exists any known constitutional defect.
No, Your Honor.
All right, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Jackson?
Just, Your Honor, we'd ask you to follow the recommendations.
All right. Mr. Jackson, is there anything you'd like to say on your own behalf?
No, I don't, Your Honor.
All right. So in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law and the protection of society. There was a COBS agreement to a sentence of 1 year jail with credit for time served. And this sentence would run concurrent to all other charges. So it is the sentence of the court that Mr. Jackson will serve 1 year. Well, hold on a second. Okay, go. In determining, did I already do that whole one? Yeah, I did it. All right. So it's sentence the court, you will serve 1 year in the Lenawee County Jail. We'll give you credit for 1,139 days already served. And this sentence will run concurrent to all sentences that you are currently serving. Now we'll assess $130 crime victim rights fee and $68 in state costs. And I will not place you on probation. Anything else, Mr. Glazier, on that recommendation?
No, Your Honor.
Now, Mr. Jackson, we are going to mail to you 3 copies of your notice of right to appellate review. We're going to have you initial and date 1 copy, and they'll mail it back to us just so we know that you received the paperwork. The other 2 copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
No.
All right. Good luck to you, Mr. Jackson. Thank you.
Y'all have a nice year.
You too, sir.
Thank you, Your Honor. And that's all I have with you this morning.
Yep. I'll see you later, Jen.
All right, we'll see you later.